silent in jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the charges in this indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with your lawyer, Mr. Hubbard?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Mr. Hubbard, do you waive a formal reading of the indictment for purposes of this plea?
Yes, so waive.
And do you waive any and all defects in the indictment for purposes of this plea?
I do, so waive.
Your Honor, at this time, the state is unaware of any outstanding warrants related to these charges. Mr. Arnold, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading guilty today?
Yes, ma'am.
For the record, the count 1 is possession of a firearm by a convicted felon. The minimum is 1 year and the maximum is 10 years. Counts 3 and 4 are both misdemeanors, which the maximum sentence is 12 months. Mr. Arnold, do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Count 1, 2 years to be served on probation with 40 hours of community service. Count 2 will be null pros. Count 3 will be 12 months to be served on probation concurrent to count 1, and count 4 will be 12 months to be served on probation concurrent to count 1 as well.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively, which means one after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you are on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence between 1 and 5 years?
I understand you.
Did you say that you do understand, sir?
I couldn't hear what you were saying. It started static.
I'm sorry, I'll repeat it. Do you understand that doing so, which means possessing a firearm, will result in a new criminal charge for which you face a sentence between 1 and 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by a jury,
Yes, ma'am.
the right to remain silent,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
and the right to appeal if convicted of these charges at a trial.
Yes, ma'am.
Is it your decision to waive these rights and enter a plea of guilty today?
Yes, ma'am.
Has anyone forced, threatened, promised, or coerced you to enter a plea of guilty?
No, ma'am.
Is it your decision to plead guilty because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of possession of a firearm by a convicted felon, and 2 counts of obstruction of a law enforcement officer in indictment number 21 SC 179541.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition?
Yes, ma'am.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file a habeas corpus petition?
Yes, ma'am.
Okay, thank you. Your Honor, this incident occurred on July 28, 2020. Officers Hill and Montgomery with Atlanta Police initiated traffic stop on a red Dodge Charger after witnessing the vehicle fail to signal while at an intersection. The vehicle did not stop when blue lights were activated and continued driving into a nearby apartment complex at 1350 Mason Turner Road, Southwest. That's in Atlanta, Fulton County. Mr. Arnold attempted to exit the vehicle. He put the vehicle in drive and attempted to flee. He drove at approximately 100 feet before being blocked in the apartment complex by another civilian's vehicle. He then exited the vehicle and fled on foot. He had a black satchel on his chest that officers observed him manipulating while he ran. Officer Hill caught up with Mr. Arnold and put him in handcuffs. A passerby notified Officer Hill that Mr. Arnold had taken the bag off of his chest and thrown it into nearby shrubbery. Officer Montgomery found that black satchel, which had a loaded Taurus G2 pistol. The firearm was discovered stolen out of Atlanta on the 18th of November, 2019.
Sir, do you understand the nature of the charges against you?
Yes, sir.
You understand all the rights you're giving up by entering this plea?
Yes, sir.
You're giving up all those rights freely and voluntarily, knowingly and intelligently?
No, sir.
Now, I want you to listen to me. Are you giving up all your rights freely, voluntarily, knowingly, and intelligently?
Oh, yes, sir.
Are you satisfied with the services of your counsel, Mr. Hubbard?
Yes, sir.
Do you have any questions of Mr. Hubbard or of the court?
No, sir.
Are you pleading guilty, sir, because you are in fact guilty?
Yes, sir.
Is counsel satisfied that your client is competent in understanding that the plea is voluntary?
I am, Your Honor.
I find the defendant is competent to enter the plea. I find the plea is voluntary. I find there is a factual basis. I will accept the plea and negotiate, and sentence is negotiated by the state and agreed to by the defense. Good luck to you, sir. Thank you, Mr. Hubbard.
Thank you, Judge. Mr. Arnold, I'll be in touch with you,
I
okay?
think we have Mr. King. You're out here. Any other private attorneys? Mr. King, who do you have?
I just,
You sure me, Mr. Hubbard?
no. I said I just had my copy.
Oh, I don't.
Is that the gentleman right here raising his hand?
Mr. Hubbard?
Yes, just give me a second.
So it's been like a good minute.
Yeah, please give me.
I need 1 minute.
I need a second.
Excuse me, sir.
I need to make sure probation.
Yes, sir.
I was trying to, could Mr. Hubbard come back to the screen?
Mr. Hubbard, if you'll come to the screen. Yes, sir.
About the 11 months thing?
As I told you, Mr. Arnold, I will get in contact with the parole board, but I'll also talk with probation. I'll get in contact with the community supervision, okay?
Yes, sir.
Okay.
Probation, do you need to say anything to him?
Just, I'll give it to Mr. Hubbard, because I don't think he's getting out right away.
No, I'm gonna send him back. I'm gonna send him back. I just wanted to make sure.
No, I'll give
Okay.
it.
I just need the indictment.
I didn't have your.
I gave y'all, I printed out a copy and put it over there on your stuff. Is it the one you just wrote all over?
No, but this is the one that I pulled out of my. Okay, there it is. I'm sorry.
Sure.
It's going to be position 2 on the 9:30 in-person Zoom calendar, State versus Robert Riley, 22 SC 184-233. It's a motion for bond.
Is that you, Mr. King?
Okay, give me a second. I gotta bring it up. Thank you. Sorry.
Mr. King, you are muted.
What number is this?
Position 2, Robert Riley on the 9:30 calendar.
And Judge, on the screen, you'll also see a Kimberly Hawkins. Ms. Hawkins, can you turn your screen on, your camera on? She is the alleged victim in this case. She's coming on our behalf to testify if need be. I'm going to proffer, and then if the court wants to hear from her, she's here. So.
Let me have Mr. Whitener tell me the alleged facts, please.
Yes, Judge. Your Honor, before this court is Mr. Robert Riley in indictment 22 SC 184-233. He has been indicted for aggravated assault, family violence, and aggravated stalking. Your Honor, I would note that this incident stems from an incident on May 26, 2022, in which the named victim, Kimberly Hawkins, reported to law enforcement that Mr. Riley had choked her and stated while doing so, "Go to sleep, bitch." Officers at that time noticed marks on her neck. Your Honor, it's important that this court recognize that this is not the only pending case here in Fulton County. In Judge Eaton's courtroom, there is another case, 21 SC 180069, from an incident on March 9th, 2021, in which a different victim, DeMonte Weems, that's DEMONTE, Weems, WEEMS, reported to law enforcement, again, the Atlanta Police Department, that the defendant had pointed a gun at him and discharged 2 shots into the ground, telling Mr. Weems that you better get from around here. Officers did find on scene a shell. Your Honor, in state court, there are 2 additional cases. The first in time from August 16, 2019. That's case number 20 CR 00781A. In that case, the victim is Kimberly Hawkins, who reported that the defendant had assaulted her. The defendant at that time was intoxicated and had his penis out when officers arrived. The second case stems from March 20th of 2020. Again, the victim was Kimberly Hawkins. In that case, Your Honor, she reported that the defendant had grabbed her vagina and that she had been assaulted by the defendant's girlfriend at that time, Tafara Cal, that's TIFARAH, Cal, CAL. Your Honor, the defendant was granted bond on both of those state court cases with the conditions that the defendant have no contact with the victim, that he not possess a firearm, and that he not return to 740 Garibaldi Street. That's GARIBALDI. Your Honor, the defendant was arrested after the second incident in March of 2020. He was released on May 23rd, 2020, after spending 64 days in the Fulton County Jail. So it was less than a year later that he then picked up this 21 SC case, the aggravated assault for the shooting. That occurred at 740 Garibaldi Street, and the state's alleging that he was in possession of a firearm. So in violation of the bond orders on those 2 state court cases. Your Honor, also, I would note in the second state court case, there was an amended bond order after it came to light that the affidavit that was initially provided to the court from the named victim, Kimberly Hawkins, that affidavit was a forged affidavit. The court issued an order, and in that order wrote as follows. If I may have one moment. Your Honor, this is an order filed in the state court case 20 CR 00324A. And That would be the second incident from March of 2020. It was issued by Judge Jesse Lall, Lall, on May 29th, 2020. And in that order, Your Honor, the court wrote that at the prior hearing on 5/21/2020, the defense presented an affidavit purportedly sworn by the victim recanting the criminal incident at issue. However, at the latter hearing, based upon the testimony presented by both the victim and her son, G. Riley, the court, and it appears that there's an error here, but leaving out the word was, the court was persuaded that this affidavit was in fact false, and that it was not signed by the victim, and that it was not signed in the presence of a notary who was unrelated and unbiased. The testimony presented indicates that this false affidavit was created and signed by the children of the victim and defendant. Furthermore, the affidavit was improperly witnessed and notarized by the defendant's sister, Kay Riley. So, Your Honor, I understand that in the instant motion for bond, that there is another affidavit provided by, purportedly provided by the victim, Kimberly Hawkins. I've not had an opportunity to speak with her about that and about its validity. In any event, Your Honor, it's the state's position that bond should not be granted for this defendant on this case, 22 SC, for the fact that this defendant has 4 open cases in both state and superior court, 3 of which against the same victim, a 4th against a second victim with the use of a firearm, which of course he was prohibited from having and prohibited from being at that address. Even after, and I'd like to note further, Judge, that for that 3rd incident, the 21 SC case that is in Eaton, he was arrested that same day, March 9th, 2021. And he was held until March 16th, 2021, so just 8 days before he was transferred to Henry County. Why was he transferred to Henry County? Because the defendant was arrested in 2017 in that county for aggravated assault, terroristic threats, and possession of a firearm during the commission of a felony. Now, he pled first offender in that case back in 2017, but he was transferred to Henry County, and on April 21st, 2021, that first offender was revoked, and he was resentenced to 5 years probation on 3 counts of aggravated assault and 3 counts of terroristic threats. So now he is a convicted felon, and so the state is concerned that if he is released, he will pose a risk of committing further felonies in our community, that he will pose a risk of intimidating the victim, who apparently is on the call today, to presumably say none of this happened. We see that in domestic violence contexts. Your Honor, I'd also note that in listening to some jail calls, even though this defendant has been ordered in those state court cases to stay away from G. Riley, the spirit of that order appearing to be have no contact with G. Riley, the son, he is on the phone jail calls talking with someone who he refers to as G. And so it would appear that he's violating that additional condition of bond in the state court case. And then finally, just yesterday, Judge, in speaking with an individual who I believe is his current girlfriend, Miss Cal, C-A-L, he asked her, is everybody still on point for Tuesday, right? It's clear that he is leading this parade in order to make sure that everybody has the same narrative, that everybody will be ready to recant. And so we're asking, Your Honor, that you deny bond for the fact that this defendant, now a convicted felon, presents a risk of committing further felonies if he's released. Clearly, he can't abide by state court bond order saying, don't have a firearm, don't go to this address. And secondly, that we're concerned about him intimidating witnesses and influencing or obstructing justice, as evidenced by that affidavit that was later found by the state court judge to be forged. So for all those reasons, Judge, we're asking that bond be denied in this case.
All right, Mr. King.
Let me back up and start fresh with Miss Hawkins is on the phone here. These two have 2 adult children together, and there is a 20-year history of them calling the police back and forth on each other later to say they don't want charges. So I want the court to understand a little bit of context here. Miss Hawkins signed the particular affidavit that the counsel is referring to that I've attached to my motion. That I didn't have anything to do with that. She sent that both to the police and now to her third DA to say that She was angry with him, and I have it attached to my motion. I can share my screen, but I have her here. I think that may be the better situation, Judge. What we've got in this situation is, number one, while it does sound bad when the state puts it that way, these issues have been addressed in the state court on a motion to revoke his bond, and they denied the motion to revoke his bond based on Ms. Hawkins getting up and explaining that it didn't happen.
Well, but the problem is when people make false allegations about domestic violence, it hurts real victims of domestic violence. What I suggest we do here is see if we can reach a global resolution of any pending case, state court, superior court, Judge Eaton in this court, and then we come back and we talk about it. That's what I think you should do in the first place, is see if you can come to a global resolution of all the cases. How long has he been in jail, Mr. King?
Judge, he's been in 131 days. We've had 3 prior bond hearings that got reset for different reasons.
Well, see if we can get a global resolution. I mean, Mr. Whitenauer, huh?
My problem with this, Judge, is I have a victim and a client that's saying this incident didn't happen, and the state's not backing off anywhere on that. So that's my problem. There's likely going to have to be a trial based on this, given the testimony going back and forth.
Well, let's try it. Let's see if we can resolve it. Have you met Mr. Whitenauer?
I have not. I've been through the 3 prior DAs.
All right, well, let's deal with Mr. Whitenauer.
This case is going to be transferred because Judge Eaton has the lower case number. So after today, this case will be in front of Judge Charles Eaton.
All right, then I'm going to transfer this bond hearing to Judge Eaton. I'm going to transfer it because the case is going to be transferred. So I'll transfer it to him and you can work with his office to get a hearing.
You said
Okay.
Judge Eaton? Is that right?
Yeah, Judge Eaton, right?
Oh, Judge Eaton. I got you.
All right, y'all have a good day. Thank you. Any other private attorneys? Mr. Hubbard, you still here?
No, I'm about to go, Judge.
We're not kicking you out. I just want to know. I don't see any other private attorneys. All right,
Judge, may I be briefly excused to grab another file? And
You may.
I'll return. Thank you, Judge.
all right.
Are we done with everybody online?
We're done with everybody on Zoom, I think. Okay,
No, I mean, as far as,
I think we're done.
well. Okay, sure.
Ms. Lugo, do you have anything?
Yes.